Good morning, good evening, good afternoon, wherever you're dialing in from. Thank you for joining us for today's YK Law Blockchain Talk with partner Sasha Levin. My name is Jesse Weiner. I'm a co-managing partner here at YK Law, a full-service law firm with offices in Los Angeles, Irvine, Dallas, and New York. We are closely affiliated with China's largest law firm, Beijing Yingke, and as a member also of the Yingke Global Network, we have access to offices and expert lawyers from around the globe. Here in New York, we have also just opened our consulting arm, YK Consulting LLC. So we are able to handle many, if not most, of your company's financial, strategic, advisory needs. So please feel free to check out our websites and get in touch with us with any questions you or your clients might have. So today we're going to be discussing the basics of blockchain technology, but then also various regulatory regimes surrounding it and various cryptocurrencies. But first off, of course, these are turbulent times to be sure. And one might have thought that Bitcoin and other cryptocurrencies billed as borderless, decentralized, alternative digital assets, like investing in gold or such, would have made great gains, market share versus traditional markets. That is basically an inverse proportionality that we've seen in previous years. But as it turns out, over these last months, we've seen much more of a similar swing in share and market value with, say, the S&P 500. Now, I'm of course no expert, and Sasha might weigh in herself during the talk, but it would seem as though that this phenomenon would indicate that there's a greater institutionalization of cryptocurrencies and blockchain in general. Because even if we look at the number of industries that blockchain has use cases for or planning to have use cases, the list is manifold. Examples: payment processing and money transfer, obviously, monitoring of supply chains, copyright and royalty protection, real estate and auto title transfers, food safety, immutable data backup, tax regulation and compliance, medical record keeping, and the list goes on. Even just the other day, it was reported that PayPal, including Venmo, will likely soon be enabling the direct cryptocurrency purchases by its users, a user base of close to 320 million. As well, China has indicated that it has completed the back-end infrastructure for its digital currency project. So a lot going on, of course, and blockchain, likely not going away. So with that, I'm going to turn it over to the inimitable Sasha Levin, who, as I mentioned, is a partner of YK and also our co-chair of the Emerging Growth and Technology Department here, and a consummate blockchain expert, and who just also happens to be in quarantine for the next few days in Israel, overlooking the Mediterranean. So frankly, she has nothing better to do anyway than talk to us about blockchain. So thank you, Sasha, for that. And also, just one last thing before I let her take over. Any questions you have, please put into the chat to the right or left, wherever it is on your screen, so we can try to answer as many of those as possible after she gives her talk. So at this point, Sasha, I will turn it over to you, and thank you all again for joining.
My background is actually as a capital markets and securities attorney with a bit of a segue into the real estate industry. And around 2015, I had the opportunity to meet with some very interesting young people in Brooklyn here, or back in New York, where I grew up actually. And they were telling me all about the really innovative technologies and projects that they were developing at the time. And to be honest, as fascinated as I was, it really started raising red flags to me and igniting a lot of concerns, certainly bringing up my early securities laws training. And so I really initially was very curious intellectually about the technology, but realized that there is really a vacuum, a real gap at the time, at least, in regulation in the US and elsewhere. Clearly between then and now, we have transform the regulatory regime in the US, the EU, and most of Asia, actually. So I think we're in a good spot today to be able to, as lawyers, advise our clients with clarity, frankly, with better budgets, and have some sense of how to comply with law. As, to be honest, all of our clients are really seeking to comply with law and just trying to figure out the quickest, cheapest ways of doing that, and it can be done. So with that, I think actually we're going to do some polls. Let me bring up my slides while we're doing that. In addition, I should say, if I just get my screen up, here you go. Let's see if that works. We are going to have slides today. For anyone who's interested in getting a copy of the slides, there's a lot of information. I realize that it is, in effect, a webinar on law, which can be a little dry. So I welcome anyone to contact me directly for to get a copy of the slides, and you'll see at the very end of my presentation will be my contact information. In addition to the work I do at YK Law, working with startups, and oh, hold on, let's admit some more people. There's a bit of background noise. I don't know, Jesse, if you can hear that. We can just make sure.
Let me turn mine.
Ah, yes, much better. So yes, in addition to focusing on startups in emerging industries such as blockchain, artificial intelligence, cannabis, and most recently space law, which is really fascinating. I also advise and mentor startups in various accelerators, including at Wharton and in Columbia, where I went undergrad. I'm also the founder of a blockchain startup called women.io, which is, as it says there on the screen, a decentralized employment marketplace for female freelancers to find gigs on a peer-to-peer basis. Finally, I'm a board member of an amazing foundation for anyone who has a particular interest in the real estate industry and how blockchain affects that particular niche. There is a Dutch foundation called the Foundation for International Blockchain and Real Estate Expertise. I welcome all of you to get involved. It's non-for-profit and it has groups really everywhere in the world. All right, so before we move on, let's do a little poll. Most of you have voted. I think we have 3 more people who haven't voted yet, but I want to just get a sense of where your background is in blockchain, which I think would be helpful. Oh, I see we do not have Satoshi Nakamoto.
Well, I was just going to say, Sasha, that this poll I clicked on anonymous, so I understand if Satoshi, if you are there, it is okay. You can elect the I am Satoshi. Okay, here's the answers for the polling.
Okay.
And share results.
Okay, so most are beginners, which is fine. I think, just to be clear, I think one of the last slides actually has a list of some further information, including Satoshi Nakamoto's white paper on Bitcoin, which is sort of one of the best and free, by the way, ways to introduce yourself to the underlying technology, which is blockchain. Unfortunately, we're not in the scope of today's 1-hour webinar going to have too much time to really go into to be granular about what this technology is. But to the extent I can, I will certainly try to explain some common terms that we use within the industry. Okay, how about the next poll, Jesse?
Okay. No, sorry, next one. Sorry, not that one. Okay.
Actually, while you're doing that, I'll just bring up the next slide. I can. Oh, there we go. Huh. Okay, we have 3 more minutes. Yeah.
Asia, okay. And nobody out there from Seattle. Yeah.
All right.
Okay. Very good. There we are.
Yeah. Okay, great. So we're pretty evenly split between North America and Europe, which is good to know. hold on, one more person who's just joined us. Okay, great. So having said that, let's move forward. Again, I want to leave some time at the end for questions. So obviously we are a law firm. I do have to put out a disclaimer that this is meant to be a general overview. This is not legal advice. You are strongly encouraged to seek legal, tax, and financial advice. This is not for the faint of heart, but we are still in early enough stages in this industry that there's really room for everyone. Okay. Okay, so let's briefly talk about the technology. What is tokenization? And let's see if I could. Okay. So according to Deloitte, the tokenization of assets is the process of using a blockchain token. They call it a security token. It's not necessarily a security token, but in effect, so let's go back for a second. A blockchain token is basically a digital representation that is created on a blockchain, on one of many blockchains that is out there, which in effect represents an actual asset. It's similar to securitization, for those of you who are familiar with that process. But in effect, it allows for fractionalization of various assets, which simply is not likely to happen without blockchain technology. And that can be an asset in real estate. It can represent an interest in an investment fund. And it also, as you'll see below, provides many benefits while facing some challenges. And so the benefits, as you see, is that it provides liquidity, right? Real estate in particular happens to be, as we all know, a rather illiquid asset class. However, using a token which represents some right to the real estate, whether it is an equity right, a debt right, a window, a square foot or meter, it can then become more liquid. And so if you think of it, for those of you familiar with the REIT concept, the real estate investment trust concept, which for the most part developed due to the tax benefits, in effect, that's what we're seeing today, is sort of a digital version of a REIT, where you have one corporate entity that purchases a property of whatever class, and it is the shares, for example, of that corporation that are then digitized or tokenized and sold in the open market. Again, subject to the regulations that we'll talk about, but that's something, to be honest, is in effect already in existence. REITs, public REITs are traded in the markets. However, this is meant to provide greater liquidity. It'll be faster and cheaper in theory, provide more transparency and more accessible to a new class of investors. Some of the challenges that exist are actually mainly regulatory. We'll talk about that further on, but I think we're actually getting to a good place. You'll note, by the way, throughout the slides that I provided sources where possible so that you can do your own further research. Again, further challenges when it relates to any sort of real asset is the custody of the asset. There have been cases where, I won't name names, but certain tokens that represented themselves to be, for example, tethered to a fiat currency like the US dollar, needs to, in effect, have an audit to verify that they actually have access to those funds or the real estate assets or the artwork or the gold, et cetera, et cetera. Governance of the tokens is also challenging. We'll talk about that further on. And of course, it's susceptible to hacking and volatility or lack of stability. Okay, actually, before we do this, Jesse, our last poll, if you could do that, I'm curious what folks think without sneaking into the slide too much to see the response. What do you all think?
Here it is.
Are blockchain tokens regulated in the United States? We're swinging the other way now. Yes, no. Who knows? Who cares? Where are we going to land? Okay.
Okay, we'll end this one. And going once, going
What
twice,
do we
and
got?
still going. One more and done. Okay, share results.
Okay. All right. Very good. So, yes, those of you who said yes, you are correct. They are regulated in the US. It's interesting to see this poll now, frankly, because when I do these presentations around the world, actually, in the early days, I found that the bulk of my audience would respond no, that they are not regulated. I think people are a little bit more sophisticated now than they were 2-3 years ago, but there you go. All right, so here is a list of, a list of US states. As you know, in the US, we have a federal system of government. The bulk of the talk today will actually be focused on federal law. 50 states is a little difficult to give an overview for in 60 minutes. However, here is a highlight of what I call the blockchain-friendly US states. Again, please at your own convenience have a look at these, but I would highlight, of course, Wyoming, which is actually a very interesting state. It's often been called the Gibraltar of the US in terms of its push to regulate in a way that actually encourages innovation rather than discourages. But there's a lot happening in our state of New York as well. We'll talk about that a little bit later on, but I would say overall the securities laws at the state level, which are called blue sky laws, generally for the most part mirror federal law with some exceptions. However, depending on how the tokens are categorized, which we'll talk about in another moment, the states may have, forgive the term, they may actually trump federal law when it comes to regulating cryptocurrencies and blockchain tokens. Okay. Let's see. Nope. There we go. Okay. So in the US, much like in the EU, we are somewhat burdened by having many, many regulators. In some of the small, I guess, island nations, where there's often one regulator, it's actually more conducive to react quicker to innovations in technology such as blockchain or others. Here in the US, this is just a quick overview to give you a sense of where we are. The securities regulator, the SEC, views blockchain tokens, not in all cases, as I want to distinguish, because that's an error that many attorneys make, views many of the tokens to be securities. There are exceptions to that rule, which we'll talk about later. The CFTC views some of the tokens or coins to be commodities. FinCEN at the Department of the Treasury views them as currency or money. And of course, the IRS, our tax regulator, views it as property and therefore taxable. And so for those of you who are subject to US taxes, I would encourage you to speak to a CPA, an accountant in the US, because this is not a simple process. I won't go into it now, but it's kind of shocking when people drill down and realize that, okay, well, perhaps if you sold your Bitcoin or Ether and exchanged it for dollars, it sort of makes sense that you may be subject to US tax. However, it actually may be the case that even if you exchange it for another cryptocurrency or another coin, you may also similarly be subject to tax laws. So please be careful when it comes to reporting your taxes. There are also additional rules and regulations that you need to be aware of. Of course, KYC and AML, that is know your client, and anti-money laundering rules, countering the financing of terrorism rules. There are industry-specific rules. So for example, in real estate, there is something called FIRPTA, which affects foreign buyers of US real estate. Blue sky laws I mentioned, those are the state-specific laws, the securities laws. And then, of course, there are new laws at the state level which relate to the requirement for some companies, for some individuals to have and apply for and receive a virtual currency license before they can actually operate. One in New York is commonly known as the BIT license. I've been working with the DFS, the Department of Financial Services. It is not an easy process, but it's much better than it used to be. Some other states, such as Rhode Island, and now California, Oklahoma, and Hawaii, are also considering the adoption of an additional similar act. Okay, for those of you, since we do have quite a number of participants today from outside the US, I thought it might be of interest that the SEC is actually trying to collaborate with other countries' securities regulators and other non-governmental agencies to provide some sort of global standard where possible, in particular to protect investors. Here is an example. If you're interested, please feel free to research any of those individual agencies. Okay, now I don't think we want to have an entire class on securities laws. For those of you who are interested, the basic act upon which US securities laws is based is the Securities Act of 1933. Obviously, it was enacted in response to the terrible stock market crash in 1929. And the basic premise of it, much like in other countries, is to protect the so-called unsophisticated investor. In other words, the US Congress felt that or the major cause behind the stock market crash is that there were sort of so-called insiders that had access to information about the stock markets as opposed to the average investor who did not have that access. And so the premise is basically providing information, the same information, to make it a level playing field in effect. Okay, so as you see in the middle in capital letters, the basic principle of US securities laws is that all securities offered and sold in the US must be registered with the SEC or comply with an exemption from registration. Okay, so registration is basically, as we know, much like we call it an IPO. It could be a secondary offering. It lists on a stock exchange, or there are exemptions that will go through where if you follow and comply, you do not need to do a full registration. There are benefits and there are disadvantages to each of them, which we'll talk about shortly. Okay, some of you may know that a security is usually what we refer to as a stock, a bond, but in the US, it also includes an investment contract. In 1946, there was a case, which I won't go into, but it relates to orange groves in the state of Florida, where the US Supreme Court determined what is an investment contract. And you see here at the bottom are the pillars of what that became known as the Howey test. Okay, and to be clear, each of these elements has been adjudicated in courts, ad nauseum, frankly. And so I won't spend a lot of time on this, but I think it's important for those of you who are considering creating tokens, buying tokens, that they may not be a security. However, frankly, between us, just among friends, the easiest way to comply with US law is to assume that the token is a security. However, we are happy to take your money and do a full-blown Howey test analysis that'll give you a sense of how likely or not your token would be considered a security, and then work with you to figure out a game plan from there on in. All right, so here's an overview of the most common exemptions from registration. Some of these will go into more detail shortly. Regulation S affects those of you who want to avoid the US market altogether. It's actually an offshore safe harbor, non-exemption, but you cannot offer or sell to US persons. Regulation A or A plus is a relatively new phenomenon that was introduced in the Jobs Act during President Obama's presidency, and it is sort of a mini IPO. It's a public offering, but it has caps of $20 million or $50 million in its offering, depending on which tier you fall within. Regulation D is actually the most common exemption that's being used in the blockchain space. I've done it with my clients as well, and it's a private placement to those who qualify as accredited investors. We'll talk about that more later on. Regulation CF also is new. It was introduced in the same Jobs Act. CF is a crowdfunding exemption. It is a public offering, but it has a very low cap of $1.07 million, so keep that in mind. Rule 701, most have not heard of. I just wanted to put this out there where there are those of you who may be considering offering tokens to employees, consultants, or advisors as a means of compensation. You need to be aware that that actually may trigger being considered an offering of securities unless you qualify for Rule 701. And then Rule 144 really applies to the restricted securities, primarily under Regulation D, when they no longer become, they are no longer restricted, and you can resell them again if you qualify under Rule 144. I'm not going to go through this entire slide. This is directly from the SEC website. I provided a link above where you can see the minutia, the real details as to which among the major exemptions, Regulation D and Regulation A and CF, and see what could work for you and what may not work for you. Okay, so I'd like to focus for a bit on Regulation S because I think it's frankly shocking to a lot of people outside the US when they hear me say that they may actually still be subject to US law even if they're outside the US and they are not offering anything inside the US. And so, as I mentioned, this is a safe harbor for securities offerings and sales that are actually made offshore. Now, as I mentioned, sales to all US persons are prohibited. That doesn't just mean people located in the US. That means anyone who qualifies as a US person who may be living outside the US. And so therefore, it's the responsibility of the issuer of the token to verify that whoever is purchasing the tokens or receiving the tokens in some way is not a US person. Okay, in addition to that, you must make sure that there are no what's called directed selling efforts in the United States. And that, by the way, could mean, as I say later on in the slide, that your website would be considered directed selling efforts unless, for example, you block US IP addresses. I think that's not well known and a pretty simple and straightforward thing to do. So if you take away anything from today, I would advise you to consider blocking US IP addresses until you've spoken to a US qualified attorney. Now, if you sell outside the US your securities or security tokens under Regulation S, they cannot be resold to US persons for at least a year. And even then, they still must be registered or comply with another exemption from registration. I talked about the IP addresses, and I think, to be honest, the technology is not the same as sort of a traditional security. So, for example, in the old days when we would purchase, let's say, a share of Coca-Cola, we would be issued a certificate, right? A share certificate. Now, if there were securities that were sold outside the US following or in compliance with Regulation S, there would be a legend on the certificate that says this is a Regulation S restricted security. And so then the stock markets, transfer agents, brokers, they all know how to deal with that. One of the challenging things with a Reg S token is obviously how do you prevent that from going back to the US? That's a challenge on the technical side, but we'll talk about some ways to deal with that as well shortly. I would like to just mention, as I pointed out at the bottom of this slide, that sometimes this is something I used to do quite often for clients when I worked in London, where you do two simultaneous offerings. One in the US under Regulation D, which we'll talk about, and then another outside the US. And they are in effect two independent securities. And so that's why, as I mentioned earlier, it may be difficult, again, from a technical perspective, to actually keep them independent. Here's a quick suggested list of tasks that you can expect your attorneys would advise you to do if you're doing a Regulation S offering. Excuse me, as I mentioned, if you're concerned or insistent that your token is not a security, certainly you want to do a Howey test analysis. You want to look at which jurisdictions you are selling the token into, which jurisdiction do you want to incorporate in. We suggest strongly that you do some sort of disclosure document, which is usually required actually under the law of whatever jurisdiction you're in. We call it here a Regulation S private placement memorandum and subscription agreement and confidential purchaser questionnaire. The next bullet point is something that I think is for the coders, which is it possible to code into your token that it cannot be transferred to a US person? Here, just to get technical for a moment, we're talking about a bigger issue of working with identity on the blockchain, digital wallets. How do you identify who the token buyer truly is? And I know for a fact that there were US persons who were restricted from purchasing tokens in some of these offerings around 2017, who somehow managed through a cousin in Rome or in Paris or Singapore to use the cousin's digital wallet and still get access to the token. So I think that's something that is of concern to the SEC in the US. But I think the key here is that if you are issuing tokens, you need to make every effort to show that you did whatever was technologically possible to prevent them, okay? And again, even the resale of the tokens is an issue. So you need to be concerned not just about the initial sale of the tokens, but to whom those tokens can be sold in a secondary market. And then finally, it is our advice that you should do KYC checks on your token buyers as well for your own local jurisdiction compliance. Okay, Regulation D. So as I mentioned, this is sort of the most common exemption that was used for token sales in the US. It is considered a private placement, and generally speaking, no public marketing is allowed. And the securities or the tokens can only be sold to accredited investors. And now here, what's interesting is unlike an IPO or a Regulation A offering, the SEC actually does not need to approve the offering. All you have to do is file a formal notice called the Form D. There's also no cap on the amount that you can raise through a Regulation D offering. However, the tokens are restricted for at least 1 year or less, or 6 months if you are an SEC reporting company. And if you have over 2,000 token buyers, you may be subject to an additional registration under the 1934 Exchange Act. Now, what's interesting is that under the Jobs Act that I mentioned before, a new rule within Regulation D was introduced called Rule 506C. And here, what's interesting is that now you can actually do public marketing. So you can have a website, you can speak at conferences, and still be compliant with Reg D, with the caveat, and here's the tricky part, is that now you as the company issuing tokens must verify that the purchasers are actually accredited investors. What that means is that it's not enough for the accredited investor to just sign a form that says, yes, I'm an accredited investor. Actually, now those accredited investors need to provide documentation showing that they meet the definition of accredited investor. And just quickly, as an individual and a current investor is someone, again, under the US definition, who has earned at least 200,000 US dollars for each of the last 2 years, with a reasonable expectation of that continuing into the next year, or 300,000 with a spouse, or has at least $1 million in net worth, which may actually include their crypto portfolio. Interestingly enough, the SEC has proposed recently to amend the definition of accredited investors to include not just a financial definition or financial criteria, but also one based on skills. And so in theory, for example, if you are a PhD in blockchain technology, perhaps you're actually better suited to understand the risks involved than just someone who happens to have a net worth of $1 million. We'll talk about later on. In Regulation D, there's actually no mandated form or disclosure that's required, other than simply being able to answer the questions correctly without being misleading or any material omissions to investors. However, the SEC did issue in 2017 a list of suggested questions, which I've provided below. Okay, and here quickly, similar to the Reg S list of tasks, is a suggested agenda or framework for what to do with your attorneys and your advisors. In particular, the differences here is you should, as I said, obtain accredited investor verifications. You should file blue sky filings, meaning you should also be compliant in every state within the US where the token purchasers are located. And then, as it says in the last bullet point, you may want to get a legal opinion, that is an opinion from a law firm that once the 1 year period is over, that you have actually met all the criteria, and now those tokens are unrestricted and can be freely traded. Okay, so here's a quick overview of guidance and regulation that is unique to blockchain and virtual currencies. As you see, in early days, it was mostly in response to fraud, Ponzi schemes, etc. But the most, I would say, defining moment for those of us who are blockchain attorneys is actually in July 2017, when the SEC issued a report regarding the DAO. For those of you who don't know, DAO is a decentralized autonomous organization, and basically it was meant to sort of be a collective or almost an investment fund where the group of investors would get to vote on where the funds would be deployed, and it included investors in the US. However, the SEC was very clear that the DAO was not compliant with US law. And I will say, to their credit, they did not enforce anything against I think the company is called Slock.it. It was a German group. And I think based on my conversations with the SEC, it was really meant to be a warning that perhaps you didn't know until 2017 that tokens could be considered securities. Well, now you know. Additionally, the same day, there was guidance provided in the investor bulletin called Initial Coin Offerings. I think that's actually helpful for those of you who are interested in getting a deeper sense of what the SEC is doing. But to reiterate, they did not say that all tokens are securities. And in fact, in 2019, the SEC issued a letter which stated that the tokens of a particular company called Turnkey Jet would not be considered securities by the SEC. This is a little bit unique to the US. In other countries, there are regulators, for example, in Switzerland, where you're in effect required to have the regulators sign off on any securities offering. In the US, you're not required to get this sort of no action letter, but it's really meant to be some sort of insurance policy where you are innovative and creating a completely new investment product, but want to get comfort that the SEC is not going to find you in violation of securities law. In that report, there was, I believe, in footnote 5 or 6, an explanation of how the DAO tokens were purchased using Ethereum. What I found interesting, for those of you who are curious about Ethereum and other types of virtual currencies is that the SEC actually quoted the FATF definition, that's the Financial Action Task Force that I referred to earlier on, of virtual currency, where they found that Ethereum was a virtual currency. Since then, there's been a lot of debate about whether Bitcoin or Ether are in fact securities, and to date, the SEC has decided not to pursue any action against either of those virtual currencies or cryptocurrencies. And just to reiterate, which we'll talk about in a moment, they're not commenting on what the tokens were when they were first issued. In other words, they actually might have been securities, but as of now, when they were asked to ask the question, they do not consider them to be securities. However, obviously that doesn't mean that you're not under any other regulation. Now that you're a currency, you're under all the other money transmission and currency rules. This is the list that I was mentioning earlier. There are some sample questions that the chairman of the SEC provided that should be addressed when you are doing Regulation D or any kind of offering at a minimum. And I have to say they're pretty basic, right? I mean, the questions that a token buyer would want to ask is, who am I contracting with? Who is issuing this token? What does the token represent? Where are you located? How do I sell my token? I mean, this is sort of basic stuff, and you can understand that the background to this is actually because many token buyers did not receive this information. And so clearly he felt the need to advise that token issuers provide that information. Here are two very important cases that followed the Dow report. I know some of these people, unfortunately, privately, and they actually got out of it relatively well. I mean, there was no jail time. There were civil penalties, and what was interesting is that in these cases, the SEC required the company to provide an act of rescission. In other words, where the company had to go back to all of its token buyers and say, okay, well, we violated US securities law, you have the right for a refund. Here's a quick overview of some more recent legal updates. I don't want to go through all of them. The first one I think is important for those of you who have more of a background on the technology side. Director Hinman at the SEC made a comment in 2018. That's the first bullet point on the slide, where he said something interesting, which was difficult for lawyers, frankly, to comply with, because he said, when answering whether Ether is a security, he said, if the network on which the token or coin is to function is, quote unquote, sufficiently decentralized, right, then the assets may not represent an investment contract, and therefore they are no longer a security. So there's the rub, right? What is sufficiently decentralized? At what point is a token sufficiently decentralized? This is not a legal term. This is not even a defined technical term. So that's an open question. If you scroll down a little bit lower, you'll see the first Regulation A offering was done in, was qualified actually in 2019 for $28 million. And that actually opened the gates, in my view, for Reg A security tokens that can be traded immediately. But it's a bit of a process because it requires SEC approval, as I said. A few quick points here. This past February, SEC Commissioner Hester Peirce proposed Rule 195, again, addressing the sufficiently decentralized issue, where she basically suggested a sort of regulatory sandbox, which is popular in particular in the UK, where issuers who are innovating but are concerned that they may violate US law actually will have 3 years to, quote unquote, become sufficiently decentralized and therefore not be a security. Okay, there is a big case regarding Telegram. Some of you are on its social network. I won't go into the details, but it's been really fascinating to watch that case. Oh, there I am. I hosted Congressman Warren Davidson from Ohio at Consensus 2019, where my startup hosted a lounge, sort of a simultaneous conference within a conference. He introduced the Token Taxonomy Act, which is the first significant piece of federal legislation. In 2020, as it says here, there were 22 bills introduced for 2020, I should say. And the breakdown is interesting. It's nearly evenly broken down to cover, providing regulatory clarity for companies in this space, how to prevent the use of cryptocurrencies for criminal purposes, and how the government itself can actually use the technology. Here's a further breakdown of those bills. I won't go through all of them, but I think it's interesting for those of you who want to follow where the government is going with this. And then I want to leave some time for questions. So here is my slide for more information. You can also reach us at the firm, but there's a lot of good information here. Again, you don't need a PhD in blockchain to get involved if you're new to this industry. I think there are plenty of resources, including the ones I've listed. The first one being the Satoshi white paper that I said I described earlier on. And then finally, that's me. Happy to speak with any of you. You can reach me via any of the social media networks. My email is alevin@yklaw.us if you'd like a copy of the slides. And with that, let's go into questions. Okay.
Yes, indeed. Thank you. Appreciate that. I think that was maybe a little more than basic. That was more like maybe 2.101 on the blockchain. But that was incredibly very informative. Thank you so much. We only a couple of questions here, it seems. That's fine. I think, well, Brian had asked about regulated by SEC as a security, but I think you had several slides actually on that sort of been answered. The whole question.
Yes, I think you know the answer to that, which is yes.
Right.
Yes,
well,
I mean, I think, look, I think what's interesting, right, they're regulated as securities, but they may not all be securities, right, as I mentioned. So I think where there are some more innovative types of tokens that represent, for example, reward points that can be traded, like air miles, they may not necessarily be securities. So I think that's sort of the more interesting part of the technology, is sort of monetizing assets that may be virtual themselves. And in that case, certainly if the SEC has not issued a no action letter for a precedent, something similar, then that's what we do. We work with clients to have discussions with the SEC, which are usually informal. You don't necessarily need a full-blown no action letter, but certainly if you want to get as comfortable as you can that your token is not a security, I would definitely suggest looking into getting a no action letter.
Oh, thank you. That actually was another question I had here. Examples of tokens not a security. So thank you. So rewards, air miles. Anything else comes to mind, or are those kind of the main ones?
You know, it's hard to list them because they're so rare. The truth of the matter is that many of these tokens were issued by startups to basically crowdfund, right, to raise capital to develop their platforms. And so I think a good example of that is for those of you who are like my children into video games. You know, you very often get offers to prepay, right, to pre-order for video games that are coming out in the future. Well, what if you could monetize that option, so to speak, right? Or in New York, where we have a subway system that used to have tokens back when I was a kid, like actual metal tokens, right? Well, what if they were using the MTA, the Transportation Authority, decided to use the proceeds of those tokens to build a new subway station. And if I decided back in the day to hoard, you know, thousands of subway tokens at, let's say, $1 a piece, knowing that the price would go up in 6 months. Well, is that a security, right? So I think there are a lot of innovative ways to use this technology, but it's really a case-by-case basis. I think I'm comfortable saying that generally speaking, if you're going to issue a token primarily to raise capital to build a platform that doesn't exist, I think it's pretty safe to say it's a security.
Okay, fair enough. Thank you. Got it. Another one of my questions here, but okay, from Irina, what in your view is the best jurisdiction to do an ICO?
Wow, that's a good question. Thank you. So I think, unfortunately, I have to give you the typical lawyer's response, which is, it depends, right? It depends how much you want to raise. It depends what the tokens will be used for. So purely from a marketing perspective, not from a legal perspective, but from a marketing perspective, very often, you know, you're spending a lot of money on the ICO. So ICO, for everyone's reference, is basically a token sale. It stands for initial coin offering. I never liked that term because it sounded too much like IPO, but it is what it is. So if you are spending, you know, that much on marketing the token sale, then very often you are sort of concurrently trying to build, you know, an audience for your product. And so that's another question is, well, where is the platform or where is the token going to be used? If you're trying to build a base, let's say in the US, I would probably advise you to consider also selling the token in the US and making sure that it's compliant with US law. Look, there are a lot of jurisdictions out there that are claiming to be the most efficient, the cheapest, the most collaborative in terms of working with the government. And so those, for example, would be Estonia in the EU, which is actually part of a larger program they have for e-citizenship and e-identity. Gibraltar to a certain extent, Malta, all in Europe. Outside of Europe, I would say if you're looking at Asia, certainly Singapore is a great jurisdiction, but I will point out that the monetary authority in Singapore, for the most part, mirrors what the US SEC does. So they're pretty strict, but quicker to react to innovation. I will give them that. Outside of Asia, the Caribbean has quite a number of jurisdictions. I was in the Bahamas last summer working with the government to train children to become blockchain entrepreneurs. And they've introduced their own digital currency called the sand dollar. And this was just before the huge hurricane. So I think that they clearly saw the need for some sort of currency that that didn't need the participation of intermediaries like banks. Other jurisdictions, Taiwan to a certain extent. I mean, so it's, again, it's hard to say which is the best jurisdiction for you personally, for your product. But I would say if you're coming to the US and you're asking like which state, I would say probably Wyoming is the best state to go to. It's just the most innovative state that understands this technology. If anyone is interested in following a woman named Caitlin Long, she's fantastic, and she's kind of leading the Wyoming Blockchain Coalition, working with the state government to push this forward. But again, I'm happy to speak. Irina, if you'd like to contact me, I'm happy to have a conversation with you about what would work more so for you. And that's part of the discussion that you will have with your attorneys once you get started.
Since you mentioned Wyoming, maybe you might have mentioned it a bit during the talk, but how, again, those state laws jibe with national securities laws? Because we're also talking about maybe the New York bit license. I wonder kind of what also that, how the benefit of that, how that works as well with the federal securities laws.
So under, this is like, US government 101. So if we're talking about a security and there is some inconsistency between federal law and state law, federal law wins. However, if you're talking about property, and there is an inconsistency, state law wins. So the interesting challenge here in Wyoming is that Wyoming is claiming that much of these assets are properties. And therefore, obviously, in their opinion, Wyoming should have control in terms of which laws apply. They are actually working with the SEC at the federal level a bit to try and figure out how this is going to work, because while Wyoming is a great state, given these issues, so Wyoming is also a great state because it doesn't have a corporate tax, it doesn't have franchise tax, but it was the first state to introduce the LLC, the limited liability company. It's called the equality state, so it's great for diversity, but it's a little bit complicated if you're planning on having customers outside Wyoming or token buyers outside Wyoming. Caitlin had actually suggested to me a couple of years ago an interesting idea, which is, Delaware, many of you may have heard of it. It's a small state, but very important for corporate America, mainly actually because the state legal system is quite sophisticated in how they, in terms of understanding corporations and business, et cetera. And so what she suggests is what we normally do in Delaware is very often people create an SPV, a special purpose vehicle, kind of an empty shell company in Delaware to transact. And so in theory, I suppose you could create a Wyoming LLC for each of your investments without actually having to be located physically in Wyoming, but that's just for conversation. I'm not suggesting anyone do that, but I think we have to be creative. And the reason ultimately why Wyoming, sort of has my heart is I was involved in early days in the Wyoming Blockchain Coalition. And, to hear ranchers of cattle who are in the government, look at blockchain as a way of providing transparency to the supply chain of meat is incredible. I mean, they get it, right? We didn't really need to convince them very much. Whereas in other states, so you mentioned New York. I think New York is more concerned, honestly, about all the fraud and losses that were sustained by New York residents. And so they introduced the bid license in theory as a way to prevent further fraud. But it's been a very bureaucratic, lengthy process to get the license approved. And so unfortunately, I had to advise many of my own clients who were doing ICOs or token sales in the US to avoid New York State altogether unless they would get the bid license.
Got it. Thank you. And how about, I guess I think our last question, nice one here again from Irina, thank you very much, about the prognosis. Will this fear develop further? Will the hype just subside? Interestingly, I didn't read the story, but some big name just mentioned, may have seen it, that the headline says something like, Bitcoin it's just a big bubble. It'll drop down to zero and go away. I don't know if that's exactly what content, but now it seems pretty crazy at this point where Bitcoin is. But what do you think, please?
Well, look, I mean, Warren Buffett, for example, hates this stuff, right? He thinks it's a bunch of BS and pie in the sky, and you can't feel it, you can't touch it, so it's not real. Obviously, I don't agree with him, but I think, if I could tell the future, I'd be a billionaire, right? So, but my sense is that when, if you look at JP Morgan issuing the JPM coin, which they've been working on for years, honestly, while, the chairman, Jamie Dimon, publicly has issued very negative statements about cryptocurrencies. So, I won't comment on that further, leave it as it is, but certainly, Facebook and Libra attempting to issue their own cryptocurrency, or it's not quite a cryptocurrency, it's more a virtual currency. But I was in Congress last summer when this was introduced, and it really woke up Congress because Facebook has an audience of 1/4 of the world's population. I mean, imagine if 1/4 of the world's population moved to a virtual currency that did not require the banks. I mean, one could imagine that the banking systems would simply collapse. Again, I'm not suggesting that, but I did appreciate that Facebook introduced it because it really put it on the map for the US Congress. to the extent where members of Congress traveled to Switzerland to speak to the Swiss regulators because Facebook went to Switzerland to avoid issuing or incorporating in the US. Again, that's all on hold, but the last comment I would make is that I think now with having a Reg A approved token offering, having certainly compliant Reg D offerings, I think we're now in a position where we will see security tokens start trading freely. And for that to happen, we need to see, in my opinion, more exchanges, more digital currency exchanges pop up that are actually approved by the SEC as exchanges or alternative trading systems. You know, there have been rumors about T0. We've been waiting for that for a while. There's some others, you know, that are claiming to do that slowly. But I think, in my opinion, I think it's going to happen. It's just a matter of when.
Got it. Well, I'm sure you can go on for hours and hours.
I could, but I won't.
But this has been absolutely super. Thank you very much. And to everyone out there who's been listening, we have almost everybody, I think, who started off here today. So this has been terrific. Thank you all. Right, please.
My pleasure.
Yes, we'll also have slides on there, hopefully by tomorrow. And of course, also contact Sasha with any questions in blockchain or securities law. And I see some thumbs up there, so thank you very much. For today. Sasha, again, thanks.
Be safe, everyone.